Mr. Scheck,
Yeah,
let me just ask
I'll
you
tell you
that.
exactly what I know and what I don't know.
Okay.
I know that Ms. Clark just said something that was completely untrue, and she should know it. Mr. Harmon knows it, and he should tell it to the court.
Which
They
is,
didn't send any fingernail scrapings to be tested to the Department of Justice until after the opening statement in this case, long after. So when Ms. Clark gets up here and says, oh, we should know about this ongoing testing, and I'm in total good faith, to my knowledge, that's not true. Secondly, and this point has to
Mr.
be...
Scheck, no.
Well, she just said that to you.
Wait, everybody wants to get, I'm only interested in one thing.
Yeah.
Does Dr. Blake know about the fingernail
doesn't.
scrape testing?
He reports to me.
Yes, that's the only issue.
He reports to me things that he observes with respect to the testing. I knew that they were performing PCR tests. There's a big distinction that the court must realize here, and that is it's one thing to go and take a picture of a bindle that has powder in it and a set of fingernails, and go and take a picture of a strip. The necessity of a report, and I demand that they give us the reports on the items after they finish the testing on the items, so this doesn't happen. That was our agreement. Because I don't know whether the Department of Justice is saying that there was an EAB finding about a scraping on a fingernail that came from the left hand, or from a pinky, or from a forefinger, and then there's another DNA test result from a scraping from another fingernail. We don't know how they're going to interpret those tests. We don't know what they're formally saying their results are. You can't know and can't make an intelligent interpretation until you see it. And I would point out something to the court. An EAB test is a genetic marker. It is not a lesser test.
Mr. Scheck,
It is a different test.
I don't need to know this afternoon. All I need to know is, does Dr. Blake know about the result that Ms. Clark mentioned, and has he communicated it with you?
He communicated to me certain results. I don't know about PCR testing, that they were testing the fingernails. Which markers, which nails, whether it was going to Cellmark, no, I did not have that, and we were awaiting reports from them. And I think I mentioned to the court in chambers that we wanted those reports. And it was the same problem we had before with Mr. Harmon, where he was telling people about reports on samples that hadn't been tested yet, and that's clear from the record.
All right, thank you, counsel. Let me just make this observation. I think as a matter of fairness, when the reason we have reciprocal discovery is so both sides know what's going on here. We're not just turning over cards blindly and not knowing what they are. I don't think it's appropriate for the prosecution or either side to ask questions regarding scientific testing that hasn't been completely revealed to the other side. That's our understanding. So, Mr. Scheck, if you'll offer an instruction regarding that question and answer, but I think it is not nearly as broad as you seem to recollect. My recollection of the testimony is that it is a relatively oblique question and answer.
I saw
But
I'll review the transcript.
Well, seeing it on TV and seeing it here live is two different things, as you know. Okay. So I will expect those results hopefully by the end of the week.
I do have that letter from Mr. Morton, and I'll have copies given to the prosecutor.
All right. Have you and Mr. Hodgman had the opportunity to speak about this new lab that you've located, the facilities, and the ability to test locally?
No, I just got this from Mr. Morton at the court's request yesterday, so this only concerns the trace evidence.
Okay. Let me do this. Let me stand in recess then for about 15 or 20 minutes. Let me have Mr. Hodgman and Mr. Scheck confer about Mr. Morton's scientific testing. I think Mr. Cochran, Mr. Douglas, we're going to stand in recess, and I'll confer with the DNA people in chambers, and I'll keep a court reporter around. I need to meet with Judge Jaffe, so I'm going to let you all go. All right, we'll stand in recess. Yes.
47, 50, and 78. Can we take that on the record for the first time?
I'll keep a court reporter here.
Your Honor, very quickly, you told us to have it back by the end of the week. We will
Yes.
have it back by the end of the week.
Okay. Well, the other attendant issue that came up in chambers when I mentioned it was, I want some assurance that the provisions that you made in your court order of February 8th, that we're entitled to explain to the trier of fact that they have
If there's
consumed
something
part of it in
yes.
testing.
Yes. But let's see what comes back.
Okay.
Let's see if they've done anything to it, and we'll cross that bridge if and when we get to it.
May I ask the court's guidance in one matter, because I think I need to understand this, so this doesn't happen again. As I understand, Mr. Scheck has admitted to the court that he knew of the results from DOJ on the
He said he knew
fingernails.
there was testing. He doesn't know what it was, which finger, which fingernail, which pile of scrapings, what finger.
Didn't he admit that he knew the results of the testing, that it was an 1818, which is at the
No,
program?
in fact, that's not what I know.
No,
In fact, I thought it was PCR, DQ alpha testing.
no. He needs to know what you're talking about when you're asking questions about it.
I agree.
Okay.
I agree. So
Fine.
perhaps is the rule at this time that there has to be a report, a written report in everyone's hand, or a conference at least to indicate that everyone knows?
I realize that a lot of this stuff is ongoing. Both sides ought to have the same information regarding scientific testing results.
Oh, I agree. I really do.
My proposal, to make sure that this doesn't happen again, is that after they finish testing on a particular item and get a result, they write a report immediately to the court. That's how we were proceeding.
I don't know that that's necessarily practical, but
Well,
we'll cross that. We're not there yet.
okay.
All right? Draft your instruction. I'll see the lawyers and everybody else at 9 o'clock tomorrow morning. And Mr. Hodgman, Mr. Scheck, after you finish conferring, I'll be available. And Judge Jaffe, can I see you in chambers, please? All right, thank you.